Stop.
What's going on? Shit. Oh,
stop. Put your hands behind your back. Ma'am.
Ma'am, relax.
Put your hands
relax,
behind your back.
Relax.
Hands behind your back. Now.
For what?
My cup's full. You got yours? Yeah.
Oh,
March 14th, 2024. Chatham County, Georgia. Loss prevention at a local Target had been watching this woman since the day before, allegedly using a technique LP later described on camera, selecting duplicate items, cycling them through the fitting room, and filling a tote bag while leaving an empty basket behind. She was reportedly already banned from other Target locations in the county. That morning, she walked into the store with an empty bag. By the time LP made the call to stop her, that bag was full of tagged merchandise she had not paid for. What unfolded next would escalate a routine shoplifting stop into a head injury, an obstruction charge, and a hospital transport. And eventually, an on-camera admission that no defense attorney would ever want their client to make.
She's probably banned from Victory. So, I don't know if they did both, but you guys usually do all Chatham County Targets.
It has to be, I think, specifically.
Yeah, so she's probably banned from them, and that's where they got all of her info.
Okay.
And we just think it's the same person.
Yeah, well, I guess let's keep an eye on that and see if,
And she was in here. Let me make sure I'm still muted. She was in here yesterday doing the same shit, and I'm just sick of her asking, honestly. Because when they go in the fitting room, like, we can't.
Yeah, you can't really see anything.
Yeah, so hopefully her bag is full. And she, like, will double it. This was her yesterday.
Did she steal anything yesterday?
Probably.
That's about why she's looking around like that.
Yeah, she was looking real hard, she knew. But she'll, like, double select. Like, she'll get, like, 3 pairs of men's pants, 2 of the same shirt, 2 of the same purse, so that when she leaves the basket, it looks like she left everything behind.
Mm-hmm.
But she never pays for anything. Yeah, this is definitely her. She had the same phone today. So she's probably stuffing her bag right now.
She's in there now.
Still in the film room?
Mm-hmm.
Will he be able to slip out without her seeing him?
Yeah.
Go fast. Go super fast. Go so fast. It's crazy. You gonna bring the MDT in here? Grab a band form and an A and B.
Yeah.
Is that her?
Yeah, but she's just coming out like she'll swap like a size out. So she might actually be trying to do it. But
Looks like a pink and a purple something.
yeah, like she keeps coming out and swapping those sizes. So also that tells me that she plans on actually taking something today, and I know she ain't buying it. Because if she keeps actually trying it on, she wants it. And she's not gonna buy shit, because she never does. Who is it?
She just came out and grabbed more stuff.
Alright, so her bag, she's coming out. Her bag is, yeah, fucking packed full of shit.
Oh yeah. Did she just dump all that stuff in there?
Well, she left the handbasket, so her bag is full, so I'm comfortable stopping her.
You're stopping her?
Well, you're stopping, but yes. You were stopping her for the theft, yes.
Okay.
What LP just described went beyond reasonable suspicion. It built probable cause from direct observation alone. Watching Jackson select duplicate pairs of pants, shirts, and purses across multiple trips, cycling through the fitting room, and then personally seeing a bag full of tagged merchandise exit, that is the totality of circumstances test under Illinois versus Gates, 462 U.S. 213, 1983. Under Georgia Code Section 51760, the Merchant's Privilege Statute, a retailer's employee may detain a person they reasonably believe has shoplifted. And LP's direct observation here gives full legal standing to make that stop. When LP said, "I am comfortable stopping her," that comfort was constitutionally earned.
Hey Riz, come on. Ma'am, come here. Come here. Come here.
What?
Yo, come here. Come here. Come.
Hey,
Stop.
what's going on? Shit. Oh,
Stop. Put your hands behind your back. Ma'am.
Ma'am, relax.
Put your hands behind your back.
Relax.
Hands behind your back. Now.
But what?
My cuff's full. You got yours? Ma'am, stop resisting.
Okay. All right.
You're about to get
Stop
obstruction.
resisting.
I got a concussion. Damn.
42 Charlie.
42 Charlie, Black female 95. Get
Hold
a
on real
EMS
quick.
supervisor for use force.
Use the force yourself.
Damn.
No, I tripped her back.
That's my fucking
She kept
head.
pulling from me.
Hold on, I need to call my
Let go of the
kids.
phone.
I gotta call my kids.
Man, let go of the phone. You're under arrest for shoplifting and now obstruction as well.
Jackson's physical resistance did exactly what Georgia's obstruction statute requires to trigger a second charge. Georgia Code Section 16-1024 requires only that a person knowingly and willfully hinder a law enforcement officer during a lawful arrest, and resisting cuffing qualifies. That resistance converted a misdemeanor shoplifting stop into 2 separate charges. Now notice what does not happen immediately following the arrest announcement. Jackson is formally under arrest. Custodial status has attached. No Miranda warning is delivered anywhere in this video. Every statement she makes from this moment forward will face a Miranda admissibility question before a judge.
Ma'am, you made me hit my fucking head.
I didn't make you hit your head.
EMS, you called in?
Yeah, they're not.
Damn. Boy, I made me hit my fucking head.
On.
EMS is in or out.
Charlie, for Charlie 1.
Damn.
Go inside.
Charlie 1.06 Charlie on the first street.
Y'all made me hit my head.
No, ma'am, you did that to
You
yourself.
got EMS coming to check you out.
My shit hurting.
Back up, please.
My head's spinning.
EMS is in or out.
Have a seat over there.
Okay. I can call my kids real quick.
No, not right now. You have ID on you? No ID in your bag? What's your name?
My fucking head is spinning.
What is your name? Jackson?
Yeah. You made me hit my head, bro.
No, ma'am, you did that to yourself. Pulling away from me.
Can I please call my kids? Boy, y'all made me hit my head. My shit's spinning. I ain't gonna lie.
EMS is in or out.
I'm about to pass out. I ain't gonna lie.
EMS is in or out.
Boy.
We have cold packs. You want some ice?
What do you want to show? What else?
Can I please call my kids real quick?
Now, can you give me
I
a
need to
second?
tell them I'm not coming to the school, and I need to call my daddy nurse.
Okay.
We'll get that taken care of.
Boy, my head's spinning. I ain't gonna lie.
EMS is in or out.
My shit is thumping. I'm about to fucking pass out. I'm not playing.
EMS is in or out.
Y'all about to take me to jail?
Yes.
Absolutely, yes.
For what?
Shoplifting and obstruction.
Can I please make one phone call?
Man, give me a second. When I put you in the car and ready to transport, I'm gonna let you make a phone.
Boy, my shit thumping.
EMS is in or out. Ma'am, sit up in the chair. Ma'am.
That was a very controlled fall. Ma'am.
Turn it over on her side. Turn it over on her side.
Get on your side. Get on your side. Get on your side. If you're gonna play this game.
Just keep running her side.
Yeah. Ma'am.
We're taking all of that.
Where are you located?
Ma'am.
10-9.
Miss Jackson. Miss
Yes, sir.
Jackson.
What's your location?
Oh, you guys want to come here?
Yeah.
Listen. EMS is coming. Let's stop playing these games. Oh, let me show you. Or move the, put the cuffs on the front.
Ma'am, stay still.
We're moving your handcuffs to the front.
You want to put the cuffs to the front? And you just stay still. Put your hands in the front. Roll over this way. Ma'am. Ma'am. Roll over this way.
We're gonna move your handcuffs to the front.
You want to sit up?
Come, sit up. Sit up.
Hang on. Miss Jackson. Just let it be.
Just take the cuff off there.
Miss Jackson, do you want an ice pack for your head? Huh? You want to get back in the chair now?
2 CR41 is trying to
Huh?
10 more. You can go ahead and
You're saying you can't move? EMS here.
EMS is here to check you out.
So, we stopped her out here. She started pulling away from me. And I had a hold of her and she was pulling away from me, and so I tripped her foot. She fell back and she did hit her head. We got her back up. She walked in here with us fine. Then she said her head was pounding, and then she sat down in the chair in there and then fell, very controlled manner, fell out of the chair and then started having what looked like a seizure on the floor.
The officer told EMS directly I tripped her foot. She fell back, and she did hit her head. That is a voluntary, first-person disclosure of the force used to effect the arrest. Under Graham versus Connor, the force is evaluated for objective reasonableness based on the severity of the offense, whether the suspect poses a threat, and whether the suspect is actively resisting or fleeing. Jackson later confirmed she was trying to flee. "I could not run. You tripped me." A leg sweep is not classified as deadly force under Tennessee versus Garner, 471 U.S. 1, 1985, which requires a genuine threat of serious bodily harm before lethal force is authorized. That threshold was not crossed here. However, the concrete impact and resulting injury make this a real exposure point in any civil action that follows.
But if I'm not mistaken, if you have a head, wouldn't you immediately have that reaction? Okay.
Sometimes it's slow.
She's right here. As you
Yeah. What's going on?
Hey.
What's going on? Alright, well, we're gonna try to get you set up, okay?
Oh,
Can you sit up for
I'm
us?
scared.
We'll sit up.
Gotta
Come
be
on.
able to look at you. I'm scared.
What are you scared of?
Oh, my eyes.
Straighten this leg up. Alright, let's check your head out. Watch out.
Did she at all look like she lost consciousness?
No.
No, she was still talking to y'all.
Yeah,
and everything?
yeah.
Okay.
Yeah, she asked if she can call her
she
kids
had-
multiple times.
She had
I don't have-
what seemed like a
I don't feel like
seizure.
bumps or
But
anything.
it was very
Oh, my neck
controlled.
is hurting down here. Where did she hit her head on the concrete outside?
That's
Yeah.
what, yeah.
Okay. We up on that concrete. I already know that I'm hurt, and I already know I'm hurting. Ain't nobody can tell me otherwise that my head not spinning, my shoulder not hurting, and my back not hurting. They ain't got to tell me that. I already know that. Y'all trying to be rude to me because I'm black. Because I'm black, that's why. How she gonna tell me that I'm stealing? She see me take something out of people's stuff, y'all accuse me of stealing. That's what that is. It's okay though. Because God see what y'all doing.
Okay.
What's up, brother? How's it
Impending incident.
Hi, are you Mr. Jackson? Hey, I'm Derek. I'm in the ER nurse taking care of you.
You need to take me to the jail.
What's that?
Take me to the jail.
I don't do any of that. I'm in an ER.
I don't want to be seen. I said they need to take me to the jail.
Oh, okay.
Y'all ain't gotta tell me that my head hurt, my fucking head is spinning.
I didn't say anything
My
to you.
head's spinning,
You
my
guys
back
want to take her?
No, I would like her to be
Sign
cleared.
off.
Oh, yeah.
Yeah, if you guys just give us paperwork saying she refused treatment, we'll take her to jail.
Perfect.
Thank you.
You got it.
All the white people work together. All the grins and smiles. Y'all got secret little codes that y'all do.
Ma'am, what are you talking about?
Just
What are you
ignore
talking
it.
about?
Duh, know me because I'm black.
It has nothing to do with race. It has to do with you had a bag full of merchandise. You had a bag full of merchandise. That's what it has to do.
How you know I was stealing?
Because you didn't pay for it. That's called stealing.
Did she see me take some?
Doesn't matter. You didn't walk in with it, and you walked out with it.
I didn't walk in with a bag.
You didn't walk in with a bag full of merchandise, ma'am.
She didn't know if I had merchandise.
All the merchandise had tags on it. What are you talking about?
But she didn't know. Did she see me take it?
Just stop. This is nothing about race. There's no
Yes, it
race.
is.
No, it's not. It's you stole, and that's it. And now you're going to jail for it. You shouldn't have stole this morning. Okay?
No, you're
you
right
You made the wrong choice,
I did.
and now you're going to jail.
No, you're right about
That's
that.
what it's about. It's not about race.
I know.
It's not about race.
I did make a wrong choice.
Because if you were white and you were caught stealing, you would have been going to jail too.
No.
Okay?
She would have never called y'all.
Just stop. Stop.
Hey, Rez, we just gotta take her to the other hospital. We'll get this paperwork from them, and we gotta take her to Memorial, because they'll give us a medical clearance.
What, she's going to refuse treatment over there too?
That doesn't matter. They can give us medical clearance over there.
They can't?
That's who we have our contract with. So she can either get treated here, or take her to Memorial. She can do whatever she wants to do.
What I recommend you do is get treated. Okay? You're
don't
complaining.
need to get
You're
treated.
complaining that your head hurts.
My
Let the
head-
hospital see you. Okay? I'm tired of dealing with you already.
I know, but I don't want treatment because I know what's wrong with me. I know my head hurt, my back.
You have a medical degree. You're a doctor.
I got a psychology degree.
Are you a doctor though?
But I'm telling you, I know my body. You know you weren't supposed to trip me like that, right?
Ma'am, you know you wasn't supposed to run away. So please relax and,
I didn't run away.
stop
I couldn't.
stop all the foolishness. You shouldn't have stole from Target, plain and
Did you hear
simple.
what she just said? She said she didn't run away because I tripped her.
I couldn't run. You tripped me.
Okay.
So it was effective. Is what you're saying.
No. That's not what I'm saying.
I'm not trying to argue with you. I'm just trying to get you to understand. You were wrong. Take responsibility for what you did.
I was wrong.
Take responsibility for what you
I
did.
was wrong. I
And stop
should've
blaming
been.
everybody else around you.
But he's wrong for tripping me.
No, he's not.
Yes, you are.
He prevented you from escaping.
Do they tell y'all to trip people?
Yes, ma'am. That is it.
And my head hit the
I'm sorry.
That's
that
on you.
happened to you.
That's on you. Made a poor choice, and you got a
I
poor
did make a
reward.
poor choice.
Okay, right. And so
You're right.
and you continue making a poor choice. Never asked you to stop, and you kept pulling away, ma'am. Okay, so
Because what were you?
If you wouldn't have ran, it's a misdemeanor amount. It's a misdemeanor amount. Okay.
And
Maybe if we would have talked to you, you
we
would
very
have been
well-
released on subpoena.
yeah.
We wouldn't even took you to jail.
Yeah, because
Plain and simple.
You never told me what you were getting me for.
Ma'am,
You know
knew,
what we were
though.
getting
Come
you
on
for.
now.
No, I didn't.
Okay, so you didn't know that you could possibly get stopped by the police whenever you walked out of Target with a bunch of their stuff?
But who said that? How would she know that?
Ma'am,
You
do
went
know how
inside
good the cameras are
With
there?
an empty tote bag and clothes. You came outside with a full tote bag.
And then we see you grabbing double of the same thing.
The whole thing is on camera. The whole thing is on camera.
Okay, I'm not gonna. You know what you did. We're not gonna play games.
No, you're right. I'm wrong.
That sentence. You are right. I am wrong for stealing, absolutely, is legally the most consequential moment in this entire video. Under Federal Rule of Evidence 801 D2A, a party admission is excluded from the definition of hearsay and directly admissible at trial with no witness required. Because Jackson made this statement spontaneously, without being directly asked about her guilt, it also survives Miranda scrutiny under the spontaneous statement doctrine from Pennsylvania versus Muniz, 496 U.S. 582, 1990. She repeats the admission moments later, where the auto caption read, "sold," but the context makes clear she said, "stole." This admission, stacked on LP eyewitness testimony and a bag of tagged merchandise, creates a prosecutorial record that is exceptionally difficult to challenge at trial.
Absolutely.
Okay.
I am.
And you're also wrong for pulling away. That is why I tripped you. Okay, you're bigger than I. You were pulling away. You're doing a good job at that. So
Instead of blaming everybody else, take responsibility for what you did, and that's it.
So, and I apologize that you hit your head. Okay,
I am wrong. I shouldn't have stolen. I should not have.
and you shouldn't
And
try
I'm
to
not
pull
being
away.
a smart ass about it. I'm being serious.
Okay, so then what I recommend is that you let these people do their job and look at your head to make sure there's no underlying conditions, and then we can go through the process. Regardless, ma'am, we're just gonna have to take you to another hospital. We have to get you looked
I
at.
don't want treatment. That's what I'm telling you. I don't want treatment. I already know that I'm in pain and I'm hurting.
Well, they can help you with that.
No, I don't take medicine.
All right, I completely understand, ma'am. But either way, we gotta get your medical cleared, and then we'll take you to CCDC and get the process started, or get the process. Like I said, it's 2 misdemeanor charges. You're eligible for bail. You don't have to go before a judge. Okay, so just let these people do their job, and then let us do ours.
Sir, I'm swear I'm not trying to make your job hard at this point.
It seems like the opposite.
No, I'm not kidding. I promise you from the bottom of my heart, and I'm not being a smart ass. I'm telling you that I don't want treatment. I'm telling you.
Okay, and that's fine. And that's fine. That's your choice. Okay, but all this because you're a different color than me, and this is all this other stuff. That's nonsense.
Because y'all sitting here ignoring.
This is not because you're talking nonsense.
I see y'all smirking and grinning at each other.
When it comes to race, I don't play that.
I'm
Okay,
not being smart ass.
I'm Hispanic. What I can't. I'm a minority too. I can't be racist.
I don't want treatment. That's what I'm telling you.
So that's your choice. And you let them know that.
I told them already. I don't want treatment.
But at the end of the day, you're still going to jail.
That's fine. I understand that, but I'm telling you that I don't want treatment. I know that I'm hurting. They can't tell me otherwise.
Okay, ma'am.
My shoulder is fucking tingling and it's killing me.
Which is why we put the cuffs to the front.
It's not about the handcuffs. That's not what it came from. The pain is running from my fucking head to my neck to my shoulder.
If it's anything other than this, I don't want to hear about it. All right, this is what's going on right now. Okay, you're in the hospital. You're going to jail for shoplifting. That's it. You will get a phone call when you get to the jail. We tried to call twice. Nobody answered. All right. Let's be a big girl and deal with your consequences. Yeah, we don't need the memorial. Right?
No, I know.
Yeah.
I just called the jail.
She got 2 warrants as well.
Oh, she has warrants too?
Yeah.
Oh, okay, well then you're not going to get bail.
You said I'm not?
One at a Pooler and then one from Chatham County. So she'll already be over there.
No.
Same thing, shoplifting.
Yeah.
Where do I have warrants from? Where do I have warrants from?
I just told you. Pooler PD,
Yeah, that's what I'm saying. What for?
shoplifting. The same,
thing you're under arrest for now.
I understand that, but I don't know where I got shoplifting.
It doesn't
Because,
say.
ma'am, listen,
it doesn't say what
Reyes,
store.
listen, I'm gonna make it real simple for you. You don't get away with shoplifting anymore. Do you know how many cameras are in all these stores?
I haven't even been there.
All right, ma'am. Your face, your name is already identified and has been passed all through the state of Georgia. Every store has your picture in a database.
Date of
Whenever
birth
you
is
go
going to
in there
be.
and you shoplift from them. Put it in a database and put a warrant for your arrest. That's why that's like that. You didn't get away with it. You just thought you did because you got to leave the store that day with the merchandise.
So, I go to tell
No,
Give me the date of birth again.
you're gonna have a hold on you. You're not gonna get out.
Let us break down the legal picture from every angle. Georgia's shoplifting statute, Georgia Code Section 16814, requires the taking or carrying away of merchandise from a retail establishment with the intent to deprive the owner of that merchandise. Under $500 is a misdemeanor. All elements were satisfied before any officer made physical contact. LP directly observed Jackson taking merchandise into the fitting room, emerging with a bag full of tagged items she did not pay for, and leaving the store without purchasing. Jackson herself confirmed every element on camera before the end of the footage. The obstruction charge is separate and legally distinct. Georgia Code Section 161024 requires a person to knowingly and willfully hinder a law enforcement officer in the lawful discharge of their duties. Physical resistance during a lawful arrest satisfies all 3 elements. These are not the same act charged twice. The shoplifting arose from her conduct inside the store and upon exit. The obstruction arose from her response to the lawful arrest outside it. Now, probable cause. The entire case was assembled by loss prevention before law enforcement made physical contact with Jackson. LP directly observed the double select pattern, watched Jackson cycle through the fitting room, and confirmed the bag was packed with tagged merchandise she had not purchased. Under Illinois v. Gates, 462 U.S. 213, 1983, Probable cause exists when the totality of circumstances creates a fair probability that evidence of a crime will be found. LP's direct, real-time observation satisfied that standard without inference. Without a tip, and without a warrant, the stop and arrest that followed are constitutionally sound. The use of force. Under Graham versus Connor, 490 U.S. 386, 1989, every use of force must be objectively reasonable, based on what the officer knew at the moment of application. The 3 Graham factors: severity of the crime, immediate threat level, and whether the suspect is resisting or fleeing. Here, misdemeanor shoplifting, no weapon present, active flight, confirmed by Jackson's own words. A leg sweep stopping a fleeing misdemeanant does not reach the threshold for deadly force. Under Tennessee versus Garner, 471 U.S. 1, 1985, which requires a genuine threat of serious bodily harm before lethal force is authorized. That threshold was not crossed here. However, the concrete injury is a real civil litigation exposure point. A plaintiff's attorney will argue that softer control techniques were equally available. That argument goes to a jury, not a judge, in most civil proceedings. Miranda. No warning was delivered at any point in this encounter. After the formal arrest, the interaction at the hospital spanned approximately 15 minutes. During that time, officers engaged Jackson directly about the charges, her prior conduct, and the circumstances of the theft. Under Miranda versus Arizona, 384 U.S. 436, 1966, a person in custody must be advised of their constitutional rights before custodial interrogation. Under Rhode Island versus Innis, 446 U.S. 291, 1980, interrogation means any questioning or its functional equivalent, including words officers should know are likely to elicit an incriminating response. The hospital conversation sits in a gray zone. Officers were largely responding to statements Jackson initiated herself. Her most incriminating admissions arose as her own contributions to a dialogue she began and sustained. Under Pennsylvania versus Muniz, 496 U.S. 582, 1990, spontaneous statements not made in response to interrogation remain admissible without Miranda. But the extended exchange where officers urged Jackson to take responsibility is functionally interrogative. Defense counsel will file a suppression motion. Given the LP testimony, the footage, and the spontaneous character of the primary admission, the prosecution likely survives even a partially successful challenge. The admission, "You are right. I am wrong for stealing," absolutely. Under Federal Rule of Evidence 801 D2A, a party admission is excluded from the definition of hearsay and directly admissible at trial. No witness needed. No chain of custody required. Jackson's statement was on camera, in her own voice, made without being asked directly about her guilt. She repeated it moments later. This admission appears across 5 separate statements, each building on the last. The repetition defeats any claim of confusion or duress. Combined with LP eyewitness testimony and the tagged merchandise in her bag, the prosecution's case was already strong before Jackson opened her mouth at the hospital. Her on-camera confession made it airtight. 2 pre-existing warrants, one from Pooler PD and one from Chatham County, were discovered after the arrest. Both were for shoplifting, the same offense Jackson was being arrested for that morning. Those warrants had 3 immediate consequences. First, they converted a cite and release misdemeanor into mandatory custodial arrest. Second, they eliminated bail eligibility entirely. Third, they establish a prior conduct pattern that the prosecution may introduce at trial under Federal Rule of Evidence 404B to prove knowledge, intent, and absence of mistake. Jackson's claim that she did not know she could be stopped for this is directly contradicted by 2 prior arrests for identical conduct across 2 jurisdictions. Under Utah versus Strife, 579 U.S. 232, 2016. The existence of valid pre-existing arrest warrants strengthens the legal foundation of the stop and undermines any suppression argument. No challenge to the initial LP stop will gain traction in this case. Now, the grades. The officers receive a B+. From the moment LP made the call through the end of the footage, officers acted on solid probable cause. Charges were announced clearly on camera at the moment of arrest. EMS was called within seconds of the injury. Officers repositioned Jackson's handcuffs to reduce shoulder discomfort and maintained a de-escalatory tone through a difficult 15-minute hospital interaction. The officer's voluntary disclosure of the leg sweep to EMS reflects transparency, not concealment. However, the complete absence of Miranda through a post-arrest conversation that repeatedly touched on the charges and Jackson's culpability is a procedural vulnerability under Pearson v. Callahan, 555 U.S. 223, 2009. Qualified immunity may protect officers where the unlawfulness of their conduct was not clearly established. But a Miranda advisement at the moment of arrest would have cost 15 seconds and protected every statement that followed. That step was skipped. Overall textbook probable cause, proportionate force, consistent professionalism under provocation, with one avoidable procedural gap that no retroactive analysis can close. Miss Jackson receives a D-. Her most consequential decision in this video was not stealing the merchandise. It was saying, on camera, "You are right. I am wrong for stealing. Absolutely." That statement, repeated across 5 separate moments, is a party admission under Federal Rule of Evidence 801D2A. It is the centerpiece of the prosecution's file. No defense attorney can explain it away, cross-examine it, or challenge its foundation. It is her own voice, unprompted, on video. Before that admission, she had already converted a misdemeanor shoplifting charge into 2 charges by physically resisting arrest. A decision she effectively acknowledged herself. "I could not run. You tripped me." She arrived with 2 outstanding warrants that eliminated any possibility of the cite and release outcome the officer described. Her extended hospital dialogue produced statement after statement that a skilled defense attorney would have told her to never make. To her credit, once at the hospital, she ceased physical resistance, cooperated with handcuff repositioning, and clearly articulated her refusal of medical treatment, which is entirely within her legal rights. None of that reverses the legal damage already recorded on camera. Target loss prevention receives an A-. From the beginning of the footage, through the decision to stop, LP built a textbook probable cause case through direct eyewitness observation, prior day knowledge of Jackson's method, real-time surveillance of the double select pattern, and personal confirmation of a bag full of tagged merchandise exiting the store. This evidence package surpassed the reasonable articulable suspicion threshold of Terry v. Ohio, 392 U.S. 1, 1968, well before any officer made contact. LP's proactive communication with officers during active surveillance allowed law enforcement to position before any confrontation occurred. The one gap, Jackson had reportedly been in the same store the day before, using the same technique. That prior visit, without a documented ban or formal trespass notice, was a missed opportunity. Had LP issued a formal criminal trespass warning after that prior day incident, Jackson would have faced an additional criminal trespass charge the moment she stepped back through the door. Meticulous surveillance, solid legal foundation, effective coordination with law enforcement, with one process gap that is entirely correctable going forward. 4 lessons from this encounter. First, the right to remain silent exists for exactly this reason. Ms. Jackson's admission is the prosecution's anchor, and it was entirely voluntary. Repeated across 5 statements, it is the kind of record that makes a defense attorney's job nearly impossible. The Fifth Amendment right to remain silent is not an admission of guilt. It is a constitutional protection designed to prevent exactly this outcome. Exercise it at the scene. at the hospital, and anywhere else before consulting an attorney. Second, resisting a misdemeanor arrest doubles the charge and eliminates discretion. At the moment of arrest, Jackson faced a single misdemeanor shoplifting charge that, without prior warrants and without resistance, might have resolved with a citation and a court date. Her resistance added obstruction under Georgia Code Section 1610-24 and made jail mandatory regardless of the warrant situation. The resistance converted a best-case outcome into an impossibility. Third, the "did she see me take it" argument has no legal traction. You walked in with an empty bag. You walked out with one packed with tagged merchandise. Georgia Code Section 16814 does not require a witness to observe the hand-to-bag movement. Concealment of merchandise and unpurchased removal are the operative elements. The before and after observation, documented by LP and on camera, is the case. Fourth, outstanding warrants from prior incidents follow you into every new encounter. The 2 warrants discovered did not arise from that morning. They were the unresolved consequences of prior shoplifting incidents. They eliminated bail, mandated custody, and established a prior conduct pattern that Federal Rule of Evidence 404B allows prosecutors to use at trial to prove knowledge and absence of mistake. Every unresolved warrant is a compounding liability waiting for the next encounter to activate it. If you made it to the end of this breakdown, thank you for watching. This is exactly the kind of case where the legal details matter as much as the footage itself. If you want to understand what is really happening in these encounters, the case law, the rights, the procedural calls that change outcomes, hit that subscribe button and turn on the notification bell so you do not miss the next one. See you there.